clauses, my lord.
Please, Mr. Venugopal, don't behave like a big boss. That's not the way. 1 minute, please, Mr. Venugopal. You also don't have papers. They also don't have papers. You also, please. If that may not be. Otherwise, we'll permit you to file a suit against SEBI. You fight it out. Then. We have to then permit him to file a suit against you and fight it out in a civil litigation. Don't have that kind of feeling that what we do, nobody can touch us. That kind of feeling should not be there. If you have sold something which you did not have title or they did not have title, which cannot be passed on to him, accept it. Or otherwise let them sue you for. That is wrong. They are selling property. Look, Mr. Dattat, I've had some experience in selling properties in the company code. I know what happens. At times, documents are not available. If we accept that principle, next time you will be in a problem. Nobody will purchase any property sold by you. Now, Mr. Sibal, before going into all other aspects, how do you propose to get 10,000 crores into
As I said, this embargo on us should be lifted.
What embargo?
Well, first of all, no embargo that we cannot sell, Mother.
You can sell.
But Mother, you will not get a buyer, Mother, at that rate. No, my suggestion.
What? You can't get a buyer at circle rate? But we are 1 minute.
Touch Sahara property. People are not willing to touch Sahara property.
In this case, once you get approval of the court, you get everything.
Therefore, Mother,
you get a better price then.
1.18 and 19 have been settled now. These just have to be disposed of. We find the settlement agreement on record for status.
There's a settlement agreement, it's already on record with us. There's an application also. It can be allowed.
No, it won't be affected by the SEBI orders or anything. Mr. Nafti, can you just confirm? Can you just confirm that? We'll take it up at 2.
There are 20 informed all concerned to remain present. And those are one of the 54 applications which we have circulated for your option consideration. I don't know whether
this is not an application in that bag. This is a separate civil appeal. We filed an IA in the civil appeal.
What is the issue involved in that?
It was a delayed possession compensation case with the NCTRC allowed. They are in appeal against that. I filed a cross appeal for grant of further interest. This court directed.
You are the home buyer? And who are you?
And for the Sahara
developer. Sahara India.
No, but isn't Sahara the entire group?
No. This is
different.
There is also another order asked. Two other one order of SEBI. That is pending. There is another matter pending. Entire Sahara.
They have to be consolidated and sold.
So what has happened in this case?
Wait for your turn. It cannot be disposed.
Your Lordship directed them to deposit money in 2016. That money is since lying here.
Very well, please. But we cannot give preference to one set of creditors over the other set of creditors. 1 minute, please. Maybe you have got a degree, but the law as it operates, as I understand, is a degree does not give you a preferential right. Mere degree or even attachment before judgment or after judgment doesn't give you a preferential right. And in fact, if you go by the Companies Act, strict principles, any execution put in motion is also to be set aside. I'm not saying anything more, but that's the law.
This court directed them to deposit and
we have 1 minute, whatever you have received, please be happy. But now we'll have to deal with it in accordance with the principle of pari passu.
So the first IA is
Listen, after can we do one thing? We went through the applications. In fact, my sister had also, and my brother also. Then we went through that. Can you just one, Mr. Nafte, can you just take us through the first initial orders passed by this court?
the first one.
First one. And these applications can be then we'll decide how to take them up.
It is 2013. It is 2013 volume 1 SCC N1.
Yes, please.
Your Lordship got that judgment?
Yes, please.
In short, I will explain, my Lord, what has happened. The Sahara Group, they had issued bonds under red herring prospectus. And those bonds were optionally convertible debentures. SEBI made an inquiry and found that they have done so in violation of provisions of the Companies Act, relevant SEBI regulations, and therefore these companies were directed to refund all the amount which they had taken from the investor. They filed an appeal before the tribunal. The tribunal rejected the appeal. The matter came here before your Lordship, and this is what your Lordship has said. I straight away take your Lordship to page 171, paragraph 325. So kindly come to the operative part of the order. Paragraph 325.
Yes.
We therefore find on facts as well as law. In the proceedings initiated by, no illegality in the proceedings initiated by SEBI, as well as in the order passed by SEBI, that is full-time number dated so that dated so, and they are accordingly upheld. The order passed by this court in civil appeal number so, filed by so, praying for extending time for refund of the amount as so stands.
The total amount is rupees 17,400 crores.
At that time, one company, the total amount comes to about 28,000 crores.
It's 28,000 crores.
28,000.
Do we have the list of companies, separate list of companies? No, we want, this is with regard to, this is with regard to Sahara Real Estate Corporation Limited, 17,400 crores.
There are two companies. Your Lordship will find that initially. So the two companies involved are Sahara India Real Estate Corporation Limited.
Yes.
And Sahara Housing Investment Corporation Limited. These are the companies.
Sahara India Real Estate.
Sahara India Real Estate Corporation Limited.
Yes.
And the other is Sahara Housing Investment Corporation Limited.
Sahara Housing.
Sahara Housing Investment Corporation Limited. These are the two companies which had issued the bonds in question.
That is of 17,400 crores.
And the other is
7,000. Sahara Housing is 7,000.
and the 17,000 and odd.
Okay. We also want, if you can give us the list of all companies of Sahara which are covered or which are subject matter of the present proceedings.
We'll give that to you.
Only two companies. Subject to what this.
Just to supplement what this is.
But the basic issue which came before SEBI, these people issued optionally fully convertible bonds. They were issued with free floating. Now, under the Companies Act, if it's a public issue, more than 50 people, then you have to issue a prospectus. The old section 67. If you don't issue a prospectus, then the money has to be returned. The major issue before SEBI appellate tribunal was, is it a public issue at all? That was the main issue. They said we are giving as a private placement. That theory was rejected, as Nafi pointed out. The court held this is a public issue. You have not followed section 67. Therefore, you must
Refund the money.
refund the money. That was it. Then what they had said that we have refunded to some of the persons. So finally, after an elaborate hearing, it was a special hearing during the vacation only for this matter. And after elaborate hearing during the vacation, the Honorable Supreme Court issued direction which Nafi will be basically direction that you have to refund the amount. Sahara has claimed that some amounts have been refunded. Verify the refund. Because they said that some people were in a hurry, there's some old help, so we gave some kind of a special case we gave. Apart from those 1,000 odd crores which claimed the remaining has to be refunded. If you can't identify the depositors, the money has to go back to the government of India. That was the short point. After that, number of applications came up. However, when as you go along, there are multiple theories. They said we have refunded the money. We said, where is the refund? At the end of the day, to cut a long story short, our stand is they have not been able to show that the monies were refunded.
So apart from that, at some point of time, this court has observed that some of the investors are fictitious.
But what happened was they said there are 3 crore investors. This was the largest public issue in the history of India. And 3 crore more than all the people in the stock market combined in those markets. Very large issue. Then they said that you have taken all these depositors. So they said, please, SEBI was asked to verify the refund. So about more than 400 trucks of documents came to Bombay. We took a warehouse. People are employed on 3 shifts. Then we found that the documents are separated. We tried to collate it. Ultimately, we got the documents collated. Now, it was impossible to write to every person and verify. So, on instructions, SEBI took the stand before the Supreme Court. You claim you have refunded the money. The money is coming in is documented through bank. But money going out, there is no evidence where the money went out, how the money went. So, we took the stand that if you can demonstrate that I had the money, you'll accept your refund theory. And I said that I gave example, suppose my daughter is getting married and I said 1,000 guests came. Now you can verify guest by guest. But if I can say that the marriage cost me 1,000 rupees per plate, I have 10 lakhs. If I show that I have 10 lakhs, that is sufficient because it's impossible to verify 3 crore deposit. Now, one theory which the Lordship has ultimately decided. My Lord Justice here in one judgment said we leave a window open. They keep claiming we have refunded. There are 7 theories of refund which will go along as it is. So, one issue is have they refunded or not? If the Lordship accepts the plea that they have not refunded, then the money has to go to the Government of India. So if they show the money has been refunded, the money will go back to them. That is the basic on the refund. Now, what has happened?
The company is still not wound up.
No.
The company never took off.
No, the company still remains on the,
Yes.
is still there on the books,
It's in the register of company.
register of company. So there's no question of company being wound up or anything like that.
The chairman also passed away. The new one. Yes. So now one thing which Mr. Nabdar also make application is Sahara has to give us to who is in management, what has happened, nobody knows. That's one aspect. Now today a number of applications are this number. A large number of applications. Now then what happened was because some of the money had gone into other group companies, Supreme Court directed an attachment of all Sahara companies.
Which is that order? What's the date of that order?
And also of the directors.
Of the directors.
And also of the
India,
directors.
all the Sahara group, including Sahara India Commercial Corporation. Because there was some accounting
One order, November 21 order 2013, which attaches. And then there's an embargo that I can't deal with any of the properties. That's what it is.
No, that was lifted partially subsequently. Yes. So kindly come to para 325 on page 171. These are the directions. In short, their appeals were dismissed. Then kindly see para 326. We have gone through each of the judgment and fully concur with the reasoning and the views expressed therein and issue the following directions in modification of the directions issued by SEBI, which was endorsed by SAT. The so-and-so would refund the amounts collected through RHP, that is Red Herring Prospectus, dated so-and-so and dated so-and-so, along with interest at the rate of 15% per annum to SEBI from the date of receipt of the subscription amount till the date of repayment within a period of 3 months from today, which shall be deposited in nationalized banks bearing maximum rate of interest. The SAHARAs are also directed to publish the details with supporting documents to establish whether they had refunded any amount to the persons who had subscribed through RHPS, dated so-and-so, within a period of 10 days from the pronouncement of this order, and it is for SEBI to examine the correctness of the details submitted. We make it clear that if the documents produced by SAHARAs are not found genuine or acceptable, the SEBI would proceed as if the SAHARAs had not refunded any amount to the real and genuine subscribers who had invested money through RHPS dated so-and-so. The SAHARAs are directed to publish all documents in their custody, particularly the application forms submitted by subscribers, the approval and the allotment of bonds, as well as documents to SEBI, so as to enable it to ascertain the genuineness of the subscribers as well as the amounts deposited within a period of 10 days from the date of pronouncement of this order. SEBI shall have the liberty to engage investigating officers, experts in finance and accounts, and other supporting staff to carry out directions, and expenses for the same will be borne by the SAHARA to be paid by SEBI. SEBI shall take steps with the aid and assistance of investigating authorities, experts in finance and accounts, and other supporting staff to examine the documents produced by the SAHARA so as to ascertain their genuineness, and after ascertaining the same, they will identify subscribers who had invested money on the basis of RHPL dated so-and-so and refund the amount to them with interest on their production of relevant documents, evidencing payments and other counter-checking the record produced by SAHARA. SEBI, in the event of finding that the genuineness of the subscribers is doubtful, an opportunity shall be afforded to SAHARA to satisfactorily establish the same as being legitimate and valid. It shall be open to the SAHARAs in such eventuality to associate the subscribers concerned to establish their claims. The decision of SEBI in this behalf will be final and binding on the SAHARAs as well as subscribers. SEBI, if after the verification of the details furnished, is unable to find out the whereabouts of all or any of the subscribers, then the amount collected from the subscribers will be appropriated to the Government of India. We also appoint Justice B.N. Agarwal, retired judge of this court, to oversee whether directions issued by this court are properly and effectively complied with by SEBI. From the date of this order, Mr. Justice Agarwal would also oversee the entire steps adopted by SEBI and other officials for the effective and proper implementation of the directions issued by this court. We think that amount of rupees so towards the monthly remuneration payable to Justice Agarwal. This will be in addition to traveling, accommodation, and other expenses commensurate with the status of the office of Mr. Agarwal, which shall be borne by SEBI and recoverable from the SAHARA. Justice Agarwal is requested to take up this assignment without affecting his other engagement. We also order that all administrative expenses, including the payments to the additional staff and experts, would be borne by SAHARA. We also make it clear that if the SAHARA fail to comply with these directions and do not effect refund of money as directed by SEBI, can take recourse to all legal remedies, including attachment and the sale of property, bringing of bank accounts, etc., for realization of the amount. We also direct SEBI to submit status report duly approved by Justice Agarwal and expeditions when possible, and also permit SEBI to seek further direction from the court as and when found necessary. The appeals are accordingly dismissed, subject to the above direction. Now, from time to time, status reports are filed. Then the other interesting thing is that they did not comply with the direction, and therefore contempt petitions came to be filed. Contempt notices were issued.
How many out of the 3 crore investors?
So some have collected.
What is the percentage where you have been able to verify and ascertain that
So
the
some, those dates will give to your lordship. Some people have collected, their claims were found to be genuine. But substantially large portion are unknown.
they
Are
are
there any status reports produced in the
Yes, yes.
proceedings?
The status
More than
reports are-
20 status.
More than?
More than 20 status reports. As an
All genuine investors have been.
about 2,000.
So comparatively, very few investors have collected money. Their claims were found to be genuine.
what is the total amount paid out of this 17,400 plus 7,000 crore?
That's what we will be able to answer.
This 17,400, just one more. This 17,400 and 7,000 crores is the principal amount or the maturity amount?
No, 17,000 plus is the amount for which optional the bonds were issued.
That's
They are
the,
collected for the issuance of
that's the
bonds.
principal amount.
Principal amount, which was optionally convertible after 10 years.
Into what? To shares?
Into shares.
Into shares. So that conversion never,
Convertible debentures.
they were not, the conversion never took place.
Bonds were issued in 2008, litigation started in 2010.
Okay. And that 7,000 crores is also the principal amount, not the maturity. Both.
OFCDs.
And how much amount has been paid out of this?
About
Principal amount.
principal amount.
With interest, it's come to.
No. SEBI has collected 17,000 crores because the person was arrested. So not then they said unless you deposit part of the amount. you
Look,
cannot be-
they had claimed that some amount has been paid by them. How much amount has been verified and ascertained has been paid by
Very
them?
small portion.
17,500 investors have been paid, and the amount paid is 130.
A very small amount.
17,500 investors, and the amount paid is 138 crores.
That's all.
Rupees 138 crores has been,
Genuine investors.
138 crores has been paid to
17,000.
The investors.
17,500 investors.
Holders.
Bondholders.
Bondholders.
This is paid by them or by the SEBI?
SAB.
By, and how much? 1 minute. They had also claimed that they have paid some amount.
Before SAT, they claimed about 1,100 crores have been refunded by them.
Okay, fine. On verification, how much amount has been verified to and ascertained has been paid back?
One second.
Which is the latest status report where we can get the figures?
I give the latest report, what the last refund is virtually negligible. On lordship question, but the amount that is refunded, despite all efforts, we are not able to find out whether the money has gone out to the bondholders. The last theory they said was when the matter was pending, they took 17,000 crores in cash to trucks and paid the money. That's the last explanation they give. First explanation was to some sister concern. So there are 7 theory refunds.
There is no such agreement. I'm sorry to say.
Mr. Rebel, we'll hear you. Let them make the assertions, then you can answer.
Lordship asking the question. Their question was they refunded the money. Now we said to refund the money.
So you have not been able to ascertain even a single case where the,
We don't have,
So
we are not
perhaps-
able to demonstrate.
So
how
perhaps
these
there
two
is-
companies paid the money. Lordship says the bank accounts of these companies, inflows have come.
but outflows is not available.
Outflows is not available. Then they said it was paid through our sister concerns. Then I'll come to all that.
So about this refund theory, there is a mystery. In short,
But their claim is 11,000 crores has been refunded.
They came entire.
entire amount except 5,000 crores. Except 5,000 crores and odd, the rest of the amount according to them they have repaid. But that's a mystery. We are not able to ascertain how.
Justification is there, the documents are there. Charges.
They will not go into it because this court has been done this.
Before the CBFL in November, before Kabir paid everything except 2,571 crores.
Notice the decision. One more issue.
One more, when the SEBI appellate trial in November, I'll explain that once. In November 2012, they approached the SEBI appellate tribunal when the matter was pending in the Supreme Court. There they took the plea that we have repaid everything except a sum of 2,571 crores. So as a matter of safety, we'll give a check of 5,000 crores and except 2,571 crores, everything has been repaid was the stand they took. That was also disbelieved. So at the moment, Lordship will take it that the refund is not established. We'll proceed on that basis. So today what the applications are, because of the All India stay, everything got stuck. Proceeding before the National Commission, proceeding before this court. So one batch is about 5 cases before National Consumer Forum. That's one batch.
My lord, one more issue, my lord. They had to bring in the amount. There is one judgment reported and 2 other orders which say first you bring the money, then only verification. And only 15,000. My lord, your lordship's question, how much money has come in? My lord, your lordship put it to us. What is the amount deposited? Yes.
D is pretty clear.
Yes, ma'am.
Subject to satisfaction by SEBI. Whatever tall claim they make,
Yes.
if you are satisfied, we can give approval. If it's not satisfied, we take it as if it's not been paid. That's as simple as that. We need not travel beyond that.
They bring in the money first. And today they have only brought in 15,000 crore. The rest is interest. They have not paid even the principal money. That's my example.
Yes, please.
So, therefore, ultimately, SEBI was directed to sell their property. SEBI attempted to sell.
So let's see the second order, then we come to that. There is a second order also of 13-1, 13, which is reported in 2013 to SEC. 2012, 10 SEC 603. Let's come to that.
Then before that, your lordship can have a look at the order dated 5th December 2012.
5th December.
2012.
That was after this. This order is of
Main order is
September
31st
2012.
2012.
No.
Main order
This 2000.
31st August 2012. And immediately thereafter, this is the order 5th December 2012. Your lordship may have a look at that order.
5th December 2012.
2012.
Skip that. Order now.
Theory orders. So it is in 2013, volume 2 SCC 733. 2013, 2 SCC, volume 2 SCC page 733.
Is there any earlier order of 11th of September 2012 which is of relevance? That's not of relevance. Which is reported as 2012 10 SEC 603.
11th of September 2012.
Yes.
2012, volume 10 SCC 603.
Yes. Is that of relevance?
No, my lord.
That's media, because
Okay.
Tara had a complaint that there is a media campaign.
Okay, that's
Nothing to do.
nothing.
The first effective
Okay.
order after 31st August 2012 is 5th of December 2012.
Okay.
So that is again
Factual error. Factual error, may I point out. OFCD means it is conversion from the debenture to share at the option of the investor and not the other way around. So I thought I'll just correct this.
So that's clear to us.
Lordship business.
That they didn't have to even say it because that was clear to us.
what
We understood it immediately. When you give it an option, it will be the option. We take it that the option was of the consumer or the depositor.
Debenture means acknowledgement of debt. So Sahara acknowledged debt. An option was given to the investor to convert that into share.
Correct.
At maturity. Thank you.
Yes, please.
So this is an order against the appeal. Your lordship will see first para. The appeal is directed against the judgment and order dated 29 November 2000, passed by the Security Appellate Tribunal, holding that the same was premature and was not therefore so and so. Now your lordship will come straight away to the operative part. Para 7 in, I don't know what will the para in the reported judgment. We therefore dispose of the appeal.
Right.
We therefore dispose of the appeal and the writ petition as also the intervention application also. The appellant shall immediately hand over the demand drafts which they have produced in court to SEBI for a total sum of rupees 5,200 crores and deposit the balance in terms of the order dated 31st.
Just one minute.
You what you got it?
Just one. Demand drafts which they produced for total sum of 51,020 crores
Yes.
and deposit the balance in terms of order dated 31/8. What is the balance? Namely 17,000.
17,400 crores and the entire amount, including the amount mentioned above, together with interest, solvency. And the first installment of rupees 10,000 crores shall be deposited to the SEBI within the first week of January 2030. The remaining balance along with the interest as calculated shall be deposited with the first week of February 2030.
Just go up a little.
Etc. etc.
So this 10,000 crores never got deposited?
They took time.
They've deposited that?
15,000.
15,120 crores is deposited.
As of now. Either through the sale proceeds,
Which were permitted to be done.
permitted either by SEBI or by SAHARA.
And
Then your lordship will see on the order dated 21st of November 2013. That is the injunction order.
21st of
21st of November 2013.
just go up a little. Just go up. इसके ऊपर जाइए. Date of order क्या है? And what's the date of the first order? Just go up to the starting.
First order was 31st August 2012.
31st August.
Yeah. You have got a spare copy for the So may I read that order?
2012.
Yes, please.
Now,
We are convinced.
November.
What's the citation of the third order?
So this is a short order. I don't think it is not reported.
It's not reported.
I'll just read it out. It's a very short one para. We are convinced that the order dated 28 June passed by this court has not been complied with in its letter and spirit. In such circumstances, we direct that the Sahara group of companies shall not part with any movable and immovable properties until further order. We further direct that all the alleged customers shall not leave the country without recognition. So then this order
869%.
was subsequently modified.
Just one minute. Page 6.
Yeah. 4th June.
Senate, 22 Senate, 2014.
Mr. Mrs. Brown, the
4th June 2020.
28 10 का कहाँ है order?
21st 11.
नहीं, अभी convinced है तो order dated 28 10 का.
Petition. 2014, 8.
That the order is modified.
Not modified, sir. This is the order where we claim infringement.
Just turn to this order which we read that day. This refers to, we are not convinced that the order dated 28/10/2013 passed by this court has not been complied with in letter. What's the order of 28/10/2013?
That is directing them to deposit.
That's directed.
Again, because they come to the court and say that give us
More time. Okay, that was the time
There are a
deposit.
series of such orders.
Okay. Shall not part with movable and movable properties
Without the
of the court. Okay.
So may I read that?
And there's a modification of this order then?
2810 is the order.
6/2014.
You have also wanted to see the order of
28/10.
28th October.
Yes.
So this is how that order reads. Mr. Sundaram Ravi, Senior Counsel, appearing for respondents, brought to a notice. The letter dated 17th of October was received from the Managing Director and CEO of PNB Investment Services. The same is taken on the basis of the said letter and our instructions received from Sahara Group of companies submitted that the alleged contenders are willing to make available to SEBI the original title deeds of unencumbered property worth 20,000 crores, along with the proper valuation report to the 3 weeks from today. SEBI in turn will examine the same and make their response, which shall be considered by the court on the next date of hearing. The above direction is complied with. Till the above direction is complied with, to the satisfaction of patient, the alleged contender cannot leave the country without the permission.
Okay. And this order was then modified by the order dated?
So then the injunction order was subsequently modified. That I will tell you, Your Lordship.
It was there in 2000. Supreme Court cases 751.
It is 4 June 2014 of Justice Thakur.
It was,
So this is the operative part. Your Lordship got that order?
Yes, please.
I think this is reported also.
Yes, this is reported in 2014, 8 SSC 470.
No, 57. 57.
75.
Okay.
48 SEC is a different order.
Yes, you're right.
You got to,
Yes, yes. Yes, yes, yes.
And repetition.
Yes, that's a repetition.
Your Lordship got this order?
Yes, please. Yes, please.
Now kindly come, Lord, to the direction number 3 in that para 23. We don't know what is the
26.
reported judgment.
26. Para 26.
Order dated 21st November 2013 passed by this court and dated control passed by SEBI including the sale and transfer of ownership property held by Sahara modified to the following extent. FDs, bonds and securities held by Sahara Group of companies may be encashed by the holders thereof subject to the conditions that the maturity value sale consideration of the FDs, bonds and securities can be deposited in the designated bank account of SEBI referred to in earlier parts of this order, and details of such maturity value and the same consideration furnished to this court on affidavit to be filed within 4 weeks from the date 18 bonds and securities are encashed and or transferred. Immovable properties owned by Sahara Group of companies situated in 9 different cities mentioned in the note filed by Dr. Dhawan and expected in the body of this order with an estimated value of 2,000 crores are permitted to be sold by the company's other entities persons whom such properties are held, subject to the condition that such sales are not for a price lower than the estimated value indicated in the statement filed before this court or the circle rates fixed for the area in which such properties are situated. The seller shall furnish to this court the details for the valuation of the property sold and the terms of the sale, together with the declaration that the purchaser is not related party for Sahara. Needless to say that upon deposit of the sale consideration, the title deeds of the property shall be released by SEBI in favor of the purchaser. The sale consideration of the property, less transaction cost and statutory dues on the sale shall be deposited with the SEBI to the extent the same is necessary to make total deposit of $5,000, including of the maturity value of the sale proceeds from the increased bond, securities, etc., permitted to be encashed and sold in terms of the The balance excess amount of the same consideration shall be deposited by Sahara in a separate account to be operated in National Bank, which deposits shall remain subject to further orders of this court.
Therefore, they were entitled to sell the property
At circle rate minimum.
or the permission
But,
or the circle rate or
That valuation.
valuation. And then the amount was to be deposited with the
Sahara.
What?
SEBI. Sahara account.
SEBI Sahara account to the extent of 5,000 crores.
To the extent of. Now,
Now,
this
one
circle
minute.
rate was.
What? How much amount?
Reduced.
Yes,
90% of the circle rate.
to 90%.
90%. Yeah.
July 24.
By which order?
I'll just do.
No, that's a subsequent order, but before that, my lord, there is one more order from 22nd July 24. Where the modification was made. And it's much later.
Yes,
So,
22nd July.
yes.
22nd July.
2014.
Okay. Just one more thing. Out of how many properties have been sold and how much amount has been collected?
After this order, my lord, after auctioning, when SEBI started auctioning, my lord, we found it not good because there were many attachments, income tax attachments, etc. Then, my lord, the order SEBI to inform this honorable court and it's not. Then this honorable court modified that order and said, all right, you sell your property, but not less than 90% of the circle rate. I just show that order.
And the sale proceeds were to be deposited.
And once this is sold, the entire consideration, less the amount of expenses, etc., should be deposited in the SEBI Sahara account.
Which is that order, 22nd of June 2020.
20%.
Yes. Yes.
No, what is the order of 22nd of June 2014?
22nd of July.
22nd of July 2014.
Then the order, there is one modification.
The 90% is 11th of July 2016.
What's the
90% of the circle rate. That order is of 11th of July 2016.
11th of July 2016. By which order they were allowed to then sell the property also. Sahara was allowed to sell the property also.
That I pointed out to your lordship.
No. Okay.
That modified order.
Just 1 minute, please. That they are entitled to sell the property, but not below the circle rate.
Initially not below the circle rate. That was the first modified order.
10% below the circle rate is
That is
11.
11th of July 2016.
Okay.
Now that stands as on today. There is no further modification. So from time to time, it appears that Sahara sold about 24 properties. That is as far as my information is concerned. Now, 1 minute. So the problem there is this.
How much amount has been collected?
15,000 crores have come into the account, my lord.
15,000.
15,000 odd crores have been paid.
No, that's including the sale of the properties.
All amounts which they have deposited in.
So there is another order,
On 3rd August.
21st November 2016.
So before that,
2 rates.
this is where they have been asked to develop.
No, that is all.
The sales.
That is correct. But I want to show modification. 20th November 2016 order is of some importance.
28th November 2016. Yes.
That order says, I read the relevant portion. We, however, make it clear that in any given case, if there is a proposal to sell any item at a price less than 90% of the circle rate, the Sahara shall be free to apply for permission of the court, in which event the court would pass appropriate orders after it. So this is the position. But to the best of our knowledge, they are not, at least they are not claimed to have sold less than 90%.
Okay.
So they have, and appears, they have sold about 24 properties.
But there is an IF file by SEBI, my lord, asking them to disclose the compliance, the details of the sale, etc. Because they are not given in accordance with the directions.
But we have filed compliance affidavits, not we have given copies to them. Other properties.
This is, we are referring to that only. So in all these compliance,
5 days, 5 days.
How many properties did you sell? You, was SEBI sold some properties also?
SEBI sold, my lord.
And 24 they have sold.
According to us, only 5 they have sold. Totally 10 properties alone have been sold. And title deeds have been released by SEBI, my lord. So 5. They might have sold more, my lord, but not, it's not to the knowledge, what have they reported to this?
so the compliance affidavits which they have filed, there is a reference to sale of 24 properties.
My lord, the condition in 3/8/2016 order was they are entitled to sell more properties also. Subject to the condition, entire sale consideration is deposited.
What's the date of that order?
That is 3/8/2016, my lord.
That's for movable assets.
Mobile assets. The order also says list of properties so sold and consideration received against the same is to be filed in this book.
Just make a compilation of these orders. You need not, where the judgments are there, just attach the first page of the judgment. So that in seriatim we have all the orders in one compilation.
In fact, we've sold 31 properties. Many of these figures are
One
not right, but by my.
Anyway, we'll just come.
So the affidavits that they have received,
Hand over anything.
Take over.
This one.
so there is one more order, which is very relevant in this context, and that is 19th of June 2015.
That is reported in 2015 SEC online.
19th of June 2015.
2015 SEC online. SC 540.
Can I take your lordship to the
540. What's the volume number? 2015.
2015 SEC online.
Okay, so say online.
SC 540.
So I am taking your lordship to the operative part of the.
Just one.
First direction is keeping in view the total liability which according to SEBI has risen to 36,000 crores. Approximately, the contemnor shall deposit the balance outstanding amount within a period of 18. The para 24 and told on the report. Your lordship got it, para?
Yes.
Keeping in view the total
No,
liability.
just 1 minute.
It's not there. It's
Just
online.
they're trying to get it on.
It is SEC online.
Yes.
No. Just, this is a galt case.
14 SEC 707.
SCC online.
SEC online.
It's not reported in the SCC. 2015
540.
540.
24.
Okay.
So the first direction is
After this.
Yes, please.
keeping in view the total liability which according to SEBI has risen to 36,000 crore, the contemnor shall deposit the balance outstanding amount within a period of 18 months commencing from the date of the release from custody in the 9th installment. First 8 installments shall be of rupees 3,000 crore, payable every 2 months from the date of their release from custody, and last installment shall be of remaining amount. In the event of default in payment of 2 installments, not necessarily consecutive, the bank guarantee permitted by the customer pursuant to order of this court can be entirely as
What was the quantum of bank guarantee?
the amount of bank guarantee.
Nothing was acceptable. Nothing happened.
Nothing happened.
The reason was that our objection was that there is no trigger point mentioned in the bank guarantee. That was my objection, and therefore it appears there no bank guarantee was sufficient.
So really speaking, this order you're referring to is only to the extent that the amount was quantified at 36,000.
36,000 crore.
And this order of 31/1/2019 is very important because this honorable court said to bring this much amount. She seen 31/1/2019 after
31?
31 January 2019.
But let me complete this order first.
Yes.
The direction 4, in the event of failure of the container to deposit the installment not necessarily consecutive, the container shall surrender back to the custody, and in case the person shows that they have taken into custody and committed to jail. Since only some of the properties have been redeemed by this court for sale by the container shall be free to apply for permission to sell any further property within 15 days from their release in order to enable them to raise funds for deposit and the required amount in terms of the order of this court. Keeping in view the fact that a large amount remains to be deposited by contemnors, we direct the contemnors to deposit their passports in this court within 15 days from the date of this order or before the release, whichever is earlier. They shall not leave the country without the prior permission of this court. In so far as their movements within the country are concerned, they shall keep the police stations marked mutually informed and updated on this. Thereafter, there is the 2019 order. 2019 order. Your Lordship got 31st January 2019 order.
Yes.
So kindly come to second para. The suggestion of Shri Vikas Singh. Your Lordship have that order?
Yes.
The suggestion of Shri Vikas Singh, learned senior counsel.
Yes, please.
The suggestion of Shri Vikas Singh, learned senior counsel for appealing for the contemnor that there should be a verification of the amount paid is an argument which has been made on several occasions earlier and has been kept pending for consideration in the light of the order passed by such verification would follow only after deposit of the principal amount of rupees 25,700 odd crore. We are told by the learned counsel appealing for the SEBI that out of rupees so only an amount of rupees 50 have been paid. 15,000 crores have been paid, and the balance amount out of the above 70 crore is interest amount. In these circumstances, we decline to pass any order, but direct for the person's appearance at the contemnor should be court on the next day. We make it clear that the contemnors have been summoned to the court to enable the court to pass appropriate orders because the law can take effect. Now, as far as some point of time, their personal presence was dispensed with.
No, not required. That's not required.
Then they were taken in custody. Then
Maybe that's not required. So the sum total is that we have got about 15,000 crores lying with us.
some extra amount is there. My learned will give the exact figure.
Just a minute.
about 15,000 odd crores is with us. Plus interest, about 138 crores as per you has been refunded. Rest of the amount, there is complete ambiguity in dark what has happened.
Just to supplement, multiple advertisements are issued in national newspapers calling for it.
Right.
Despite
So
that only.
we don't even know who are the owners,
No, at
whether
one
there is
point
any
of time-
claimant for that or there is no claimant for it.
At one point of time, this court was pleased to observe that these investors are fictitious. Though it's not a conclusive finding, but it's a tentative one.
Tentative fine.
Tentative one.
Okay. Now, how do we proceed from here? How do we do it?
First of all-
Now, there are 3-4 issues which, as per this order of 31st of January 2019, the verification exercise, whether they're fictitious or not, is all now not moving forward because 25,700 crores is not coming.
It has reached a dead end.
It's reached a dead end. So what do you suggest? How do we tackle that? Because there are issues in that. If suppose they are fictitious, then that money has to be put in that consolidated fund over that consumer protection fund or whatever that.
Consolidated Fund of India.
Okay, fine. Consolidated fund of it. Because normally what happens is there's a consumer protection fund. Normally,
Given to us, it's equal to the government. That is what.
anyway, it doesn't make a difference.
So what's that investor protection fund? of-
Investor protection fund is there. Normally the money, if nobody takes that money, then the money goes to the investor protection fund. That's the law.
It's under the constitutional mandate where there is no known owner, the property goes to the government.
And deposited.
One way we are not, he's arguing, Mr. Simple. We are not concluding
Our
that.
problem is this.
How do we, just 1 minute. How do we go about with this?
For recovery,
No. How do we go? Do we do the verification exercise? Because this way is virtually lying at a standstill. Suppose the amount is, the amount is, there are no claimants, it's Benami or fictitious, then that further process cannot be also made. Secondly, there could be some cases where they're genuine also, that also cannot be done. Apparently, they have not given any details to SEBI or SEBI is not satisfied with those details.
Mission Manoj intervene for a minute. Give me a few minutes. Yeah, Manoj sent documents, 247 drafts which have been digitized. In these documents, there are vouchers, payment vouchers. Manoj,
Are the payments in cash?
Yes. And
That's
vouchers.
the problem. That's-
1 second. There are vouchers, individuals.
I asked you, 1 minute please. I asked you whether the payments are in cash
That is
or
a 5,000 rupee bond, Manoj. So 5,000 rupees have been returned, the voucher is there, the person is there, the Aadhaar card is there, the photograph is there. And they're all with them. And Manoj, they don't want to verify. Manoj, they have digitized everything. I'll give you a lordship the record. So this argument, Manoj,
We'll hear you, we'll hear you.
Yes.
Matters between argument. But it will became aside for the time being. The large number of people whose application was concerning of both. Those matters can be disposed of.
Now, we'll come by one.
Manoj, may I say something else? Then there are income tax orders where these documents have been verified. And income tax orders say that yes, they are genuine. So all that will have to come, Manoj. I'll have to make that, face those facts.
Please wait. One is, do we carry out that verification exercise or not? Because we have reached a dead end because 25,700 crores is not coming.
One application where the refund theory has been tested for the last.
We'll test that.
The last and final time.
We'll test that. We'll
No,
test.
you asked to take that first or take up the other.
No, now, the other applications are in view of the order passed by this court, putting a stoppage for, there's virtually standstill or status quo because of that. Now, and that is not with regard to these two companies, it will be with regard to the other projects of this company. But it is also possible that the money which had flown in from here may have gone to the other company. But has SEBI been able to verify that aspect?
No. It's a reverse situation. money was refunded, these two companies' bank accounts did not show any outflow, only showed inflow. Then they said our sister concerns paid those monies. Who need to check that?
Mr. Tar, I'm on a slightly different issue.
Yes.
Is there any evidence to show that the money from these two companies
Yes.
had flown to the other companies, sister companies? No, don't have evidence to that effect. We don't have evidence.
Money has come in, then it's not there. There's no refund.
1 minute, please. Mr. Dattar, is there any evidence to show that the money which had come
Yes, yes, yes.
to the sister companies?
Yes.
Do we have those details with us?
Yes, details are all.
Do we have the exact details?
Some details are there.
Because the money must have gone through check. It can be only through banking transaction.
Yes.
Because the money which came in,
It's gone out somewhere.
correct. And as per the deposits made in the bank accounts of Sahara, most of them are cash deposits.
Depositors are cash depositors.
Mr. Sibel, can you wait for it? Most of these are cash deposits.
Cash.
Okay.
Almost 100%.
Most of the depositors are less than 5,000 or 10,000, 20,000.
No, there is another. Sahara has got, they said they have got Sahara firms. It's part of the Sahara Parivar. So Sahara firms are there. These firms have collected monies. So when I show you Lordship their ledger accounts, Lordship will see a large 300 crores is from Punjab National Bank. Their argument is our collection centers collect all these amounts from these depositors. This is put into one, say, bank in Allahabad. That bank Allahabad will put it into the account. So monies have come from clusters of funds and have come.
So it's impossible for you to verify the source from where the money is come. Because the collectors are depositing the money in the bank account, and then that
Transferring the savings are these companies. I show the ledger trail. Not what I'm submitting is subject to your Lordship approval. And then Amicus is
we come to that. We have gone through that chart. In fact, not in the chart, he's given us on a pen drive list of applications with we can open very conveniently open the link also. That's a huge effort which has gone into it. We'll be coming to that.
Yeah, the WTM's order also says that.
Look, there are two ways to deal with it. Just 1 minute, please. There are two ways to deal with it. One is we go application wise. Other is we take a larger picture into account, and then we try and dispose of the matter on the core issue itself. The core issue before us is with regard to these two companies and deposits. Other issues are secondary issues which have flown pursuant to the orders passed by this court because amount was not deposited in this court. So there are two ways to deal with it.
There are number of small.
Because if we start going into the individual applications, problem.
No,
So there is only one property to which I want to invite your Lordship. That is Vellore property. There are 10 I's in respect of that. There is a dispute between the buyer and Sahara. There are two buyers, or rather 3 buyers, and all of them are claiming title. They say that Sahara has entered into agreement with them. The amount is substantial. At least that should be so that.
So we are open to both we are not saying which one is more preferable.
Get more funds into the coffers. Because something has to be done because at least 25.
Just close the mic. Just close.
My suggestion is that
Just
small application can be.
Just 1 minute.
Balance amount paid about 43,000 into 17. And addition. 43.
Obviously, based on what I informed, they also have responsibility. So you must know that. Secondly, I can do it later. Yes. This then application to keep it separate. Basically, you have to live for it. I take all the other things to. She's sitting. She not. I said I see but I said there that's where it comes to those. Every moment.
So, Mr. Nafte, there are two. One is therefore we go through the applications also. The other issue is what do we do? How do we proceed with regard to that 15,000 crores which is lying deposited? Whether we should, what should be done with that money, and what should be done to ensure that at least the 25,700 crores comes to the kitty.
That amount is concerned, the Sahara still maintains a stand that they have repaid, and therefore that amount should come back to them. Now that's an issue.
That we'll have to decide.
That's a thorny issue, and
we'll have to decide that issue.
If your lordships are going to decide that issue first, then this will take a lot of time. And some of these small people.
So, Mr. Nafte, we can't keep that as a back burner also. We can't keep
that issue first and then.
That issue is unguaranteed business small application.
The home buyers, for example, they opted order.
There are number of applications. There are number of such applications. It will take a lot of
Home
time.
buyers are only 20. Only 20.
No, they are also concerned because they have lost out then.
No, one person wants to proceed with this case in the consumer court. We say no, let him.
Another wants to proceed under arbitration.
Small, those they are independent of that. They have got into the crossfire because they are dealing with some Sahara housing project in Nagpur, some Sahara housing project in outside Chennai.
But how will you differentiate cases which are collusive in nature?
No, they have been discarded.
They have opted
to the refund that has been kept separate. Where they are independent. Simple idea by what we thought of mineral ideas can be.
Okay, then we start with those.
May I suggest a way out?
Just a minute. There are two issues that's not.
One way to look at it is that we deal with the core issue. That is the question of which was how the litigation came to this court and how did the litigation come in. That is to deal with 17,400 crores plus 7,000 crores, which makes it 25,400 crores. We deal with that core issue, out of which 15,000 crores has been already corrected. There is a shortfall of over 10,000 crores minus 138 crores, which has been given, has been already accepted.
The difficulty in this, the fresh eyes are pouring in.
That's why I'm saying,
Now-
once that core issue is decided, other things can be then left off. Other things can be then left off to be dealt with at individual level rather than at the Supreme Court level.
Because we are actually trying to combine the other issues with this, because once this issue is decided, the law will take its own course so far as other issues are concerned.
That will require a detailed scrutiny by the finance
Maybe,
experts.
yes, they will require. But Mr. Sibal, we want 25,400 crores in the court.
There is no embargo. There is no embargo. I'm
When there's an issue of ambiguity for some time. Wanted to sell ambiguity because some money had wanted to buy ambiguity. Please don't sell ambiguity because other properties don't touch ambiguity. At that time, he submitted a envelope and sealed cover. They made a statement to the court that properties in that sealed cover are worth 1 lakh crores. That's what they said. Yes, and that sealed cover was never opened. So they said, please don't sell ambiguity. But if you guys have 44,000 crores, don't sell it. Keep these properties. Don't get sold. They got into problem because a lot of farmer problems, there were unclear title deeds. So that issue got sidetracked. Now, within 10,000 crores, for your lordship, there is a sealed cover with property. Up to your lordship to open it, ask them to sell the properties and deposit the money.
No. See, even with respect to selling the properties also, we have to put certain rigor on that. See, now that sufficient safeguard will have to be there. Even the earlier order in 2016 certainly requires some sentence.
Circle rates,
Yes.
There's an issue.
Yes.
Some places in Delhi, we know circle rates are higher than the market rate. In other cases, the circle rates are ridiculously low compared to the market rate.
One example in this case is, in Ahmedabad property they sold 3 times the circle rate.
No, that's right. So therefore, you will have a you will have a distinct role in that also. We'll make sure that, because it is not that they can do whatever they want, and you have to go after them. And like the information not forthcoming, sale deeds are not there. You hold the sale deed.
Sir, but sale even below 90% with the leave of this court.
That we are not doing. That we are not doing.
Affair, brothers, now kindly see. Well, at least, brothers,
No order, nothing. We
I'm just saying, brothers,
are just putting that question to them. Therefore,
Yes, sir.
fact of the matter is, there are orders of this court where they have said that we cannot sell the properties. They gave up we gave them, you sell. They gave up their right to sell. There are, one second, this is the problem. You made a statement. Fact is, you yourself said we cannot sell these properties. But now, brothers, IDC, if you sell just land, brothers, it will fetch you nothing. It will fetch you nothing. No, and brothers, nobody will be willing to buy that.
we are not. 1 minute. This is simple. Nobody is saying that you don't sell the properties. We are not barring you from selling the properties. All that was suggested by my brother was the sale should be done in a transparent manner so that obviously you will also not object to. Why will you object to that?
What happens is the value of a property depends on development, brothers. Otherwise, nobody just buy land like that. No, brothers, let them get some.
That may be stretching too much. People do buy land. You do buy land also when the land has its own market value. Developed land has its own market value.
Inside auction, they say.
For getting land developed also is also a huge issue.
If I can get a developer,
What we are saying,
get more money.
Mr. Municipal, what we are saying is, we don't propose to exclude them in that process. You do it, but they will have their sufficient role in this. Otherwise, it will be very difficult. How to ascertain the value?
What I suggest is to make the matter that the heart of the matter is taken up.
This is what should be devise a methodology by which
That's
this
right.
can be taken forward. I have no problem with
What
that.
happened was that he was the appointed state man to help us sell the property. The property because there was some impediment. I think. And what happened was Lordship was property through court auction who never faced the market price. They always go for a physical sale of the lower price. So we adopted the safe harbor rule. Circle rate minus 10%. You can sell without consulting the court. If you're still not getting a buyer, come to the court and tell, okay, there is some problem, sell the property. That is supposed to do. Now, that has not been done so far. Now, how to bring in this 10,000 crores, the balance, how to make up the deficit? Because order of Supreme Court is first finish 25,000 crores, then we proceed further. That's the mandate of this honorable court.
That's why, Mr. Thar, what we are saying is this. In that process, instead of like what they have done, according to them, see, according to you, only 10 sales have taken place, 5 by them, 5 by others.
That's also factual.
According to them, more sales. According to you, these particulars not come. So we want to have a better system to deal with it. So whereas you will have a distinct role in this process itself. Therefore, we want to avoid this. So that you get them sell it, but it's not some element of transparency should be there, and which you should also should have a specific role, say in this, so that the process will be very open and frank. That's what we are saying.
So may I suggest something?
Yes.
There are 3 properties offshore. 2 London property hotels and 1 New York plaza. They have been representing that they are going to sell those properties, will bring substantial money. Last 7 years, nothing has happened.
No, they have been sold, where they have sold. There is other property, there is not out of that.
There is an order, they are filing an saying there is no money left.
The Plaza property has been sold, Manoj. I don't know what my learned friend is saying. That hotel has been sold and brought the money back. Sahara account.
No, money has gone to Bank of China. Yes, no,
Sahara account. What are you saying?
not the foreign property.
I'm telling you, Plaza Hotel has been sold and brought it here.
No, the money.
No, but maybe the
Whatever
property,
is the-
1 minute. Maybe the properties were under some charge, start bank, so they, maybe we just know that because the properties may be under some charge or something and now.
We paid that charge and brought the balance back. Then
Just one thing, what has happened is happened.
That's correct.
The peak of the-
That's right.
They muster 10,000 crores. Lordship is saying, they
See,
can't be giving the sole
If
property. He can't be giving-
if there is any anomaly post the sale, it will create more problem. So before the sale, if you can create a better system, then that solves the problem. Let us assume that sale is not
Okay.
correct.
Now, Mr. Sibal, before going into all other aspects, how do you propose to get 10,000 crores into
as I
the,
said, this embargo on us should be lifted.
what embargo?
Well, first of all, no embargo that we cannot sell, Manoj.
You can say,
Right? But Manoj, you will not get a buyer, Manoj, at that rate. So, my suggestion.
what, you can't get a buyer at circle rate? But we are, 1 minute.
Touch Sahara property. People are not willing to touch Sahara property.
You, in this case, once you get approval of the court, you get everything.
Therefore, Manoj,
You get a better price then.
There are developers who are ready, ready to invest, ready. It's the value and the money to be brought in. But if your lordship doesn't allow that to happen, no.
Who is stopping you from that?
Therefore, Manoj, we want that
To
liberty.
play, liberty is already
And
there.
We will associate them with it. We will associate them with it.
Valuation of-
There is no,
Valuation is fixed.
to be very frank, there's no embargo on Sahara group of companies selling the properties. All that is, all the restriction which is imposed is, you sell it at the circle rate minus 10%. And in case you want to go below the circle rate, then you have to take approval of the court. In fact, better way to sell it is that they SEBI be involved by
I
e-auction.
tell your lordship, one of the real problem. Do not fetch the value of this property. Somebody invests by and large, because we have no money now, we can't invest it all, we can't develop the property, we have no money. So somebody has to come and invest and increase the value.
No, Sybil, that's not the way. I don't think that may be the right position. There are people who will buy the property, land, and with as it is situation, and say to itself, and then they'll develop it.
I'm talking about the state committee.
Okay, just give us the list of, okay, do we have the list of properties which have not been sold? Good. Just show us that.
Let me just, let them do. We'll provide.
24.
Sort of. So probably the buyer should not have any problem.
We have tried. We not go to order.
It is not court market, it is since they ask SEBI to sell it, then we engage State Bank, then there is getting delayed, then finally the court says, all right, forget it, it's your property, you know which property.
Justice Oak was appointed.
That was long back. And he was High Court.
My request to your lordship is let us give you a scheme. Let me give you a scheme as to how this is to be moved forward. And your lordship will either approve it or modify it so that it should get value, so that it should not be that everything should go for a.
Who wants, look, it's neither in their interest, neither in your interest,
Therefore,
neither in anybody's interest that the property should be sold below the market value.
so
Where the problem is that what property is sold should the figure or the rate at which the property is sold is actually the real rate. That's all.
Therefore, we will associate them. We will supposing a developer comes and says that, look, I will give you this amount of money upfront. And therefore you give me 50% of the property, I develop 50% you take. Manoj, he gives them 2,000 crores, Manoj, we'll give it to them and we'll associate them with it. It's not Manoj that we want to do anything behind their back. But if you don't allow me that, Manoj, then it's very difficult. So allow me to give you a scheme. And Manoj, let us move forward. We want to pay my.
Mr. Sybil, you're going back to the same argument. Every property has a market value. Yes, the market value will fluctuate depending upon whether the property which is developed, obviously the market value will be higher. Today, date and age, where there's already a direction and an order of this court directing you to deposit 25,400 crores. Since 2012, that's not been complied with. And if we include 15% rate of interest on that, the figure will be.
This court has modified that order, Manoj, which he didn't read. Justice Mishra said, we're not concerned with interest, we're only concerned with.
Okay, we'll also,
They are not showing.
Okay, fine.
Secondly, it's not.
So then, please tell us, how do you get that?
15,000, it is 17,000. And I give your lordship that figure. Not only that,
That's
they
good.
have taken money from other accounts of without reference to us. So they should tell us how much amount that they have from in the Sahara.
Now, please. So whether, let's say, a land which is being sold, say, in a place like Noida, it'll have a different value if it is already, roads are constructed, development has taken place. It'll have a different value, but nevertheless, when the roads are not constructed, but nevertheless, both the values will commensurate with the market value. You can't say, I will not sell it at this value, but I'll only sell it at that value.
It is admittedly my property.
Correct. Right. But it's also your judgment data to the extent you're not even able to fulfill. So we can attach and sell your property.
My property.
One minute, Mr.
Allow me to say something.
Okay.
It is my property.
Correct.
And it's my obligation. I want to discharge the obligation. I want value for my property. I'm entitled to do that. I'm entitled to get
Mr.
value.
Sybil, answer.
The lordship is putting to
These promises were given 10 years back, not fulfilled, and therefore we are at this stage.
Why not?
These words were there.
Because they tried to
The
sell.
contempt was issued.
No, that's not true. They tried to sell, they couldn't sell.
Mr. Sybil, you are right.
Yes.
You are right to some extent, but then there is one difficulty in your argument. You are today a judgment debtor. The court is entitled to attach a property and sell it. Just 1 minute. Court is entitled to attach a property and sell it. The court, while doing so, will take into consideration anybody's judgment debtor's argument that he can get a better price. Court will give you that option. But court will not wait and say, till such and such event happens, please. So today you are a judgment debtor. So please, as far as under Order 25 is concerned, we know what the powers the courts have, how to enforce it.
So even if we apply.
One second, allow me, sir. You've actually, this is a contempt proceeding. Contempt proceeding, this is happening, fine. 42 NC. Let's forget that. I'm not a judgment debtor. I'm not a judgment debtor, but in contempt proceedings,
You are a judgment debtor. as far as SEBI is concerned.
They don't want to verify.
No.
I have got the name of the depositor. I have the.
No,
of the
Mr. Sibal, there's a direction given by this court that you have to pay 25,400 crores in this court. That direction is not complied with. That's a degree of this court. Order passed by this court is a degree.
They have got 24,000 with interest at the moment. And the amount is also 24,000. The people have to be identified. It's not so simple as that. Please hear the whole matter, Manoj. At length.
You're right, 24,400, not 25,000. You're right.
24,000 with interest.
Just to
With
clarify,
them.
because since I've been there from day one, how this problem started. First, they said they got some property in Bombay, 100 acres in Warsaw. It will be sold, we'll get 42,000. It then transpired that there was an order by Justice Gaga saying this is what is called mangroves, reserve property, you can't sell it. That's why he went to jail. Then they said we'll sell Ambi Valley. Ambi Valley, they gave valuation of 44,000 crores. He said sell Ambi Valley. They said no, don't sell Ambi Valley. It's very valuable to us, it's running. We'll give a cover of 1 lakh. Now my submission is let's forget the past. I'm submitting, there are 1 lakh crore properties. Every property will be ABC category. One will be error-free property, free land which can
Exactly,
be.
that's what we're saying.
Second will be
What
differently attached-
what we will do is, let them give a list of unencumbered properties. That's right. We will restrict to that. In that, please, both of you tell us, what are the safeguards we want and what are the factors we can put in our order, so that, before sale, you will be heard, or you will coordinate with them.
Yes.
And so therefore there is no need for arguments on that.
Correct.
So let us see how to recover this amount. Once we undertake this exercise, the other application will fill in simply. Please.
Appoint a court, a sales committee by the court, one representative from them. Maybe a retired senior civil servant who.
Just tell it for us.
Or unless they can come to the court and say, I got this property in Noida, circle rate is so much, but I'm getting so much, I want to sell it. And what I'm selling 10,000, 1 lakh crores, even 10% property is also will get the money.
They will tell us how to
So just
sell
give
our
us-
property. Will tell to sell our property
No.
without value.
The court will do it.
Yes, your lordship will do it. No, I have no problem.
It's an application for appointment of receiver.
Long back.
Yes, so give us a little. Okay, just 1 minute now, please. We've got that. Look, at 2 o'clock, we want an answer to this question, how the property should be sold off. Yes, certainly the respondent, the Sahara group has to be involved. We have given them the rope to sell it, even less than 10%, provided with the permission of the court. We don't know why they are not able to do it.
Allow me to give you a scheme by tomorrow, whenever, with how I want to proceed this.
Okay.
Allow me some time.
Okay, we'll give you time till tomorrow. You give us a scheme by tomorrow. Now we go to the applications.
Yeah. Because I am in that Indian bench, we have to start arguments. After tomorrow, I give you a scheme, whether they have to, how to go. And with their involvement.
Mr. Sibal, just one question. One thing, let me make it very clear. To say that you have not been given the fair chance to sell the properties is incorrect. Prime facie incorrect. For the simple reason, earlier they were trying to sell the property, they were not able to do so. They've been given complete freedom to sell, free arm to sell the properties at circle rate, less 10% less than the circle rate, and even below 10% the circle rate with the permission of the court. So to say that you don't have a free arm is wrong. Number 2, there's an order of this court that you have to deposit 25,700 crores, out of which 1,500 or 1,700 crores has been deposited. 17,000 crores have been 24,500.
Yeah, I appreciate what.
So that order will operate as a degree in law.
This is what happening without verification. The lordships are doing this without verification.
Because the order of the court also says verification. 1 minute, please. Order of the court says verification will be done post you deposit.
No. I'll show that to you. I'll show you. That's correct, not correct.
That will leave.
Okay, that we'll examine.
Yes, please examine it. That's not correct. Day after tomorrow, I'll address you on it.
The question of verification cannot be abandoned. How can you?
We are not abandoning that question.
If I start
We will deal with it.
And let us,
to encourage or not.
Mr. Sibal, let me also put it very clearly to you, why this court had directed you that verification will be post the deposit. Because there are allegations that these are benami and fictitious deposits.
No. I will demonstrate that, Your Lordship. Allow me to argue, sir.
But that's
Their case. It is there. They don't want to verify because they know what the facts are.
147 containers of documents.
They know what the facts are. They don't want to verify.
Okay,
I will
let's start off with the application. Let's start off with the application.
For the list of property, they can decide what to
That's what
We have already said that. Let him give us key. He knows.
No embargo of all these.
There's no embargo. That's an excuse.
even that happens, ultimately, they will be the beneficiaries. As you rightly said, poor property still they will save.
Let's start from the one with
This amount, even then they can
the
save.
earliest application. Let's start from the earliest.
Taking the application, I have a suggestion there. The 53 applications that they have filed, along with interest, the total payment is 27,000. Wrong with it. That's the value.
No, that's not correct. No, on our side itself, for the Vellore property, we had paid 10 crores in 2017.
Or then you
43 crores.
If you
We had offered to pay 33 crores 7 years back. We're waiting. Today the check is with us.
That is refund from Khanna Sahara account. One thing, that is refund from David. I am not on that. I am not that. I am on the 27 applications listed today. We have Mother's calculation. With interest, the total value is 27 crores. Therefore, all my request is allow us to sell and pay so that pay off these people.
We may allow them. We may allow them.
Otherwise, what will happen is Mother's proceedings will go on.
We are going application wise for that purpose only. Yes, please.
What is to be discussed?
Thursday, we will not take up any applications. We'll go to the court.
Yes,
to-
yes. Give me of that. Give me of that.
Today for applications?
Take up the, that is hanging in fire.
So should we start with the first application? That is
Vinod-
item 53 in your list.
Not at,
Let's start with that. Let's go one by one. Let's go one by one.
Vellore is not number one. We'll start one by one. It's been sold, registered already.
No, what's registered? We have.
So the first application is number 22 of 2016.
So you're going by serial number 1 of 53.
No, I have those applications which will not require much time to dispose.
Okay. Which is serial number?
You are shortlisted, no? You are shortlisted.
122.
You have shortlisted the IS. You have shortlisted the IS.
You shortlisted the IS.
So from that, number one.
From that.
That's number 1?
No, that is serial number 122.
We only have 53.
Only today for 53 only.
Order was first 53. Order was for 53 applications.
22.
22.
I don't know why you're taking 120.
And lots of there are writ petitions also.
We'll come to that. We'll go one by one.
53.
Your Lordship has got this list.
Yes.
In that, item number 22.
Why can't we go serial wise?
Okay.
Serial.
I'm going chronologically
Yes.
because item number 1 is 23, 2023.
What is the IA number?
The I number to which I am making a reference is 27 of 2016. That's the earliest I.
तो वैसे ही जो उसने किया मैंने उससे 22 पे serial number 22 पे
Yes, so there is serial wise. You should do it serial wise.
So there is a truncated list of IS which we wanted.
Yes, please.
Serial wise now. Yes.
It runs into about 17 pages.
So, yeah.
What he's saying.
Application for?
This application is This is a complaint which is filed in the district consumer forum, pending in indoor court. They want to proceed with that.
So we'll allow that application.
Prayer is different, my lord. Please, the prayer.
Yeah, I can't open the application. There's some problem with the.
It's to intervene, intervention.
Yes, my lord.
It's only for-
Has to assist this court. There's no prayer that they should continue with it.
Who's appearing in this application?
You can't stand in that because at one point of time your lordship had said no court to proceed.
Okay, right. We permit the
Anupam Lal Das.
Mr. Anupam Das.
No, it is senior advocate now.
Okay.
But the proceedings have been dismissed by the consumer forum.
So he must have gone up in appeal.
Please to dismiss the application filed by applicant on the ground that the clarification provided by his honorable court in IAS 1 so was limited in scope and applied only to the facts of that case. So the said order does not diminish the business destination.
No, I couldn't understand this.
No, this I am not very good.
But what they're saying is they had moved the indoor.
That's been dismissed. But why was it dismissed?
Lordship.
It was dismissed because of the pendency of present
We were
proceedings.
asked to get a clarification, my lord.
Okay.
So they produced one order of this court saying this is the clarification. Yeah, so the commission says no, this is not.
Okay, we permit them to proceed. Right down.
What just passed this order, Madam, the request is there was an application filed by us in 2013 that allow us to 2015, you allow us to pay them off. And this was
That's it. No.
now interest is being, well, the bank, you don't allow us to pay them off.
No, 1 minute, please.
Then interest is being imposed on us from this. Because, and despite the fact that we were willing to settle, so why should the interest be included?
We are not going into the merits of the matter. We are look, please, Mr. Sybil, there's an answer to that question, the argument which you have raised. The answer is you are required to deposit 24,400 crores in this court. Your failure to deposit, the court was compelled to part in.
They allowed me to pay off for us, and this court said no.
Mr. Sybil, is an answer to that. That may not be correct. Write down. IA number 227 of 2016. No, 1 minute, please. This application is disposed of, permitting the applicant to proceed, permitting the applicant Rahul Doshi to proceed in accordance with law, notwithstanding pendency of the present proceedings. We clarify, we have not commented on the rights and claims, rights, interests, and obligations of the applicant Rahul Joshi or just 1 minute, or what's the name of the respondent before the, or Sahara Prime City Limited. The opposite party before the consumer court. Application is disposed of. Next one, please.
Next is I number 160.
The dismissal order passed by the consumer forum on account of pendency of the dismissal of the consumer complaint. The consumer complaint is restored to its original position and will proceed in accordance with law.
Next is 167 of 2016.
One, serial number.
Serial number 21 is that.
Serial number is 20. 167. Listen, after can we go by serial number 1, 2, 3? That will become very difficult otherwise.
The first one is I number 111 of 7758.
Yes.
111758 of 2023.
The first idea that is listed in the list.
What is the issue in this?
That was before the lawyer continued. State the consideration, the amount that I paid to Sahara price. So my lord has given price. My lords, now in view of the order of my lords, what is happening is if I can take my lords to my application. On account of that order of 21st of November 2013, The state commission is unable to execute the order because in the order.
That's not similar to that.
Commission is to be sought from the honorable Supreme.
Same order.
Same order.
A large number of such matters I can order the same order.
That's correct.
Cover the same and
Okay.
time of the board. But if you
No, but it'll have to be, names have to be then incorporated, or we can circulate a draft order. You put in the names.
Most of these. Where is permit them to execute the order. Can be done.
So the same order can be asked for all consumers, but they're all seeking permission of the lordship to proceed in the consumer court.
Okay, but
Provided
we
you
are
are-
at a different stage. In some cases, complaint is pending, some cases, order have been passed, execution is pending.
Provided the orders have become final.
That's
Some of them are for executing the orders.
No, that will be done in accordance with law, that's all. We are not saying anything on merits.
I very humbly submit that multiple state commissions or district courts are stating that we can execute only subject to permission of the honorable.
That's all right, we can say that. That's right. No embargo, no, that's what.
IA number,
111758.
IA number 111758 of 2023. This application is filed by Deepa Ingole is allowed. Permitting her to proceed is allowed, and the execution proceedings pending before the state commission, Nagpur can proceed in accordance with law.
That last part of what is protecting, not commenting on the protecting our rights is the state of consumer.
That's fine. In accordance with law, why should I even mention that? Whatever it is,
You haven't said anything on merit.
we have not said anything on it.
This
This court has not commented. This court has not commented has not commented on merits.
There's one aspect which we better point out. Suppose an order is to be executed, we don't know the extent. There are multifarious applications, several applications that we ask. The amount will have to be, Ms. Sibyl mentioned a figure of 27 crores. Maybe it's more than that. How do we pay the amount? There's a restraint.
We'll deal with that. We'll deal with
It's a larger issue, we'll deal with it. It's a larger issue.
You are not.
When you're not charged with the order that we ask.
That notice is issued in all these IAs, and parties are at liberty to file their respective replies, rejoinders, etc. So it was open to them to
But
file.
what, we are not saying anything on merit, sir. We are not expressing.
I guess regarding this, if I can point out only one order of my laws, it is dated 21st of November 2013. If that states that we direct that Sahara Group of companies shall not part with any movable and immovable properties until further orders. So my lords, on account of this particular.
Just one. Now, what will happen is, as far as your execution is concerned, it will be then for the Sahara to move for vacation of the stay for payment of that amount. And depending upon the merits of your case, they can then pay the amount.
We have not stayed the proceedings.
We have not stayed
We have not stayed the proceedings, only
Don't ask any clarification from us. It is for the execution court to decide. We will not say anything on that. Once we say we are not touching upon merit, we leave.
We don't know what's going to be the final
raise all the
consequence,
contentions. Yes.
what's going to be.
Yes.
If they come forward and say that we want to settle it up and
Yes.
pay up the amount, fine. And if we find SEBI, to SEBI it appears that the claim is genuine and the payment should be made, they can pay it.
Look, it may not be possible for us to make a blanket submission that we'll settle everything. It may not be possible for us.
May I invite your lordship's attention to an earlier order passed by this court in respect of persons who have filed complaints or have obtained orders from consumer forums, and your lordship have permitted. In terms of that, your lordship can permit.
No, we can permit. That will be, then they'll come to the court and seek permission. We don't want them to be coming to the court itself. They can approach the SEBI. They can approach the SEBI. If the SEBI finds it that the claims are genuine, let them make the payment.
The lordship can clarify that.
We'll try.
So item number 2 is slightly different. There is an arbitration award.
Yes.
We have an award, my lord, which is executable. Dated 7th October 16. My lord, we have applied for execution to the Pune District Court because the Ambi Valley, our award is against Ambi Valley Limited. The properties are, my lord, the Ambi Valley city properties. In fact, my agreement was also for a plot, to take a plot on lease in Ambi Valley city. My lord, the Pune District Court has declined to entertain my execution Go forward with it on account of.
Same order. Yes, same order.
Therefore, we will decide. There is a 34 pending.
We are not saying anything on merits, sir. We only
Taking
say-
deposit also is executable today.
We are simply going to say the execution proceedings and the proceedings all proceedings pertaining to this award can be, are permitted to continue in accordance with law. That's all. No, you will be involved.
Not at this stage.
It is paying to deposit, so it's executable. The government stays just to deposit, could not deposit because of the prohibition. That's the only problem.
We will not consider your request in their application where they want to proceed in accordance with law. Why should we say unnecessary things?
What's the date of the award?
7th October 16.
IA number. This is,
So there are two, I'm sorry, it's 4th October. No, it is 4th October 16, right, sir.
And there are two IAs, one is for improvement and the other is.
that can be allowed. Application for amendment is allowed. IA number 43715 of 2020. This application is disposed of with the observation that proceedings.
So the number is, so the numbers are 18909 of 22.
That's
And the other is 172867 of 22.
That's what I.
Can I pull up? Pull up. Item number 2. Okay, 1 minute. Item number 2.
Lorani Shipping Limited.
Schools for including and three for that.
Okay, IA number 182.
Both are instituted.
182-909 of 2022. Application for impediment is allowed, subject to all just exceptions.
And the next one is for executing the awards.
IA number
To name.
About 172867.
172867. The application is disposed of, observing that the proceedings pertaining to arbitral award dated 4/10/2016 will proceed in accordance with law. To stop, we clarify, we have not made any comments on merit.
Policy execution proceedings.
No,
So that's what is pending.
1 minute, please. He's saying 34 is also pending.
Yes, 34 will go on, of course.
That's right.
That's all we have said.
Execution proceeding will
We have said proceedings pertaining to the award will continue in accordance with law. That's all.
For the Pune district,
Yeah,
they
right.
require directions, but otherwise they may not entertain.
Will proceed in accordance with law, notwithstanding tendency of the present proceedings.
Serial 3 to 11, the same order can be passed as item 1.
Yes.
3 to?
3 to 11.
Okay. These are all proceedings.
Consumer forum.
We have a degree in our favor.
So fine, that's fine. वैसे ये वापस आने के लिए this week.
I just want to point out one thing in serial number 8. There is also IA number 58012, which is mentioned along with serial number 8. That IA is also to be allowed with this because that is not marked separately.
What is the issue? What is the prayer in that application?
Because we had spoken to the office that has got missed from the list, but it was there in the master list.
You want to know what is a prayer, so you are seeking that IA.
Money should be released. 5801.
That is close. That is close.
Money should be released.
That's close.
That we are not passing, that the executing
Very
court.
well, very well. We are disposing the main matter itself.
Still being mentioned that.
Yes, sir. Very well.
This is going to be common order in 3 to 11. But the name of the parties will have to be given. So we'll make a blanket order. Please.
The name of the applicant is there in my list.
No, but we'll circulate a template order. Parties will fill up that name so that there is no confusion. Suppose, because we will not be able to verify.
The item number 12.
Yes.
Passed in favor of Sahara
Pardon?
products.
2 to 11, 1.
You can proceed.
So directing SEBI to release.
Hello, sir.
Item number 12, my lords, is a decree which is obtained in favor of Sahara Q Shop Unique Products Grade, my lords, which again we have not been able to execute because of the restraint order of 2020.
My lord, this prayer is to release it from the SEBI Sahara.
That's not possible. We'll only say that you can proceed in accordance with the same order.
Allow us to allow the third prayer.
That's correct. You'll proceed in. That's correct.
IA number, application for impleadment is allowed subject to all just exceptions. And then let's like 264 of 2017 you record.
The third prayer, my lords.
The applicant is permitted to proceed third prayer.
Yes, my lords. Third prayer.
But they are rejecting the other two applications.
The applicant is permitted to proceed and continue with the execution proceedings in accordance with law. We clarify we make no comments we make no comments on merits. First
location. To be a location wise.
So 13 to 22.
23 is RBI.
Yes.
Same as item 1.
And 24 is going to ED.
22 same as item 1.
This is not consumer court in this country.
I'm not mentioning the consumer court.
My lord, in item 1.13, my lord, IA number 177 and 179, my lord, this is little bit different, my lord.
Which part?
IA 177 and 179 of 2016, my lord. This is
Item
item
number.
There are 10 IAs. Give to your lordship the list of those 10 IAs.
In which item number?
1.13, my lord. This is by one, my lord, the poor person, my lord, Ram Dhani, my lord. And my lord, by the joint.
Okay, just 1 minute, please. We're
Yes,
getting now confused because the stenographers will not be able to. So,
As far as those
we had
22 applications are concerned, they are over.
yes, 22 is over. So now we come to 23. 23 is well known property.
37 and 41.
No, come to 23 now. Let's come to 23.
This is Hanuman.
This is a case, my lord, where pursuant to your lordship orders, my lord, option notice was issued, purchase the property in option about 83 acres. Example, sale certificate was issued in 2018. We have paid 18.03 crores. But subsequently, when we take pattas from the revenue authorities, we have received pattas for 23 acres. 29 acres have not been granted. There are issues. So we have made a investigation. And thirdly, 7 acres out of the 83 acres was acquired by NHAI for construction of national highways. Our prayer is twofold. One is refund of that 7 acres cost which has been taken.
So you'll have to file a litigation. So did you sell the property or Sahara sold the property?
Simply sold the property. Sold the property.
That is very.
No, Mr. Bhatt. Mr. Datar, no, please. Please, Datar, Mr. Datar, please. 1 minute, please. You as a seller cannot get over your obligations. But please. Please. Wait, look, if we accept that, there's going to be a drastic fall in prices.
The auction notice had 3 clauses, my lord.
Please, Mr. Venugopal, don't behave like a big boss. That's not the way. 1 minute, please, Mr. Venugopal. look, you also don't have papers. They also don't have papers. You also, please. If that may not pay. Otherwise, we'll permit you to file a suit against SEBI. You fight it out. You fight it out then. We have to then permit him to file a suit against you and fight it out in a civil litigation. 1 minute, please. There's limits to which verification can be done by you and by him. 1 minute, then he'll have to sue who has got the money. He has to sue them. One, and in case the land doesn't belong to him, the ownership itself is missing. As is where principle cannot apply in this way.
Is there any variation?
Please, but let him then sue you. Let the civil court examine. Let the civil court examine the type cause.
So the initial phase, we are asked to sell the property.
Maybe. Be reasonable on that. That's not correct. That's not correct. We day in, day out, we're selling property. Look, Mr. Dattar, I've had some experience in selling properties in the company code. I know what happens. At times, documents are not available. If we accept that principle, next time you will be in a problem. Nobody will purchase any property sold by you. Don't have that kind of feeling that what we do, nobody can touch us. That type of feeling should not be there. If you have sold something which you did not have title or they did not have title, which cannot be passed on to him, accept it. Or otherwise, let them sue you for. That is wrong. As long as
only one clarification for this 7.44 acres is acquired by NHIA. Compensation is given to whom? Compensation. No, but did they receive it or is lying in the deposit? If it is there, then you can also look into that. Somebody can look into it.
If you have done some, check what's the area.
Please, you could have also checked it. You don't want to do anything. You put the blame. How can you? Let's not behave like this. Let's not do this. You have to be reasonable on that.
Number one is.
Look, please verify. 1 minute. Please verify the area which has been given.
7.44 acres, and the amount is one.
He will not be entitled to claim the compensation awarded from the NHS.
The amount is 162,15,614. We will refund them.
So there is another.
Just in the event of.
There's some amount lying in the deposit. Then you please take over that amount.
That's the amount. This amount which we are returning is 162,15,614.
What we are saying is, for the acquired land, valuation amount is there. Then you take that amount. We give a liberty to file application, check up, and then take the amount.
Property belongs to Sahara. People have acquired whatever they count. And into this fact, have got that money.
No, if they are not got it, because nobody knows about it. Nobody knows about it. Therefore,
they will not be entitled to that.
But neither of them will get it now. If it is lying there, and file application, get it there. We'll observe it.
If the money is lying there, please take it.
Please get it. You can take it.
There is another I connected with this.
1 minute. Application for impediment is allowed.
There is
The amount will be specified.
1 minute. Application for impediment is allowed. Stop. In view of the fact that that 7.44 acres of land was already acquired by National Highway Authority of India, and title cannot be passed on, cannot be conferred on the applicant, we direct SEBI to refund rupees 1,62,15,614 within period of 8 weeks from the date copy of this order. From the date copy of this order is received by them, no interest would be paid. Application is disposed of. Now come to the next. It will be open to SEBI to get in touch with the authorities and also get in touch with the authority to ascertain whether any compensation amount is lying deposited. Stop. Compensation amount.
Say, compensation paid to the previous owner, we can recover from it. Because Sahara got the money.
if the Sahara has got the money, they could have already 2005. What will you do
can't get
now?
it. Most probably it must be lying in the court. So you
That be
can.
the- If any amount is lying deposited, to retrieve the same and deposit it in the, what is that account called?
Sahara refund account.
Say in the SEBI Sahara refund account.
So there is another